And like, That's been about here. Yeah, I grew up in the village. That the end of my life. So they go to work out here and, you know, that's their, but,
Is what day is today? Today is May 31st, 2023. It is 12:07. I would like to call this meeting of the Nishorn Town Council to order. We have one agenda item today, which is to discuss and act on potential litigation regarding the decision of the Town of Nishorn Zoning Board of Review, recorded on May 12, 2023 in Book 570, page 14 of the Town's Lands Evidence Record. Town's Land Evidence Records related to an appeal by appellant Aldo's Bakery of a decision of the town zoning official regarding Plat 6, Lot 80. And our counsel, Nick Solitro, is with us via Zoom. He has advised that it is necessary and appropriate to entertain the discussion of this matter in closed session. But as always, we will review any actions taken after we reconvene an open session. Is that correct, Nick?
It is.
Oh, Nick.
Can you hear me? Can you hear me?
It's the most articulate you've been in months, counselor.
Can you hear me now? Nothing. Hang on.
He's rejoining. Hey, Neil.
All right. How about now? Nothing.
It did. It did. You're listed as a question mark on the invite, so it must have passed you by.
Keith, can you hear me?
Nick, we still can't hear you.
All right. All right. How about now? Can you hear me? Can you hear me, Keith? Still nothing?
I'm sorry, Nick. We still can't hear you. We're checking it out on our end as well.
Yeah,
Yeah.
Yes.
I can hear that, yeah.
Better? Let me know.
Okay.
Hey, Nick, not if you
Yes.
can hear us.
I can hear you. Yes. Yes.
Exactly. Blink your eyes twice if you're being held hostage.
Yeah.
Oh, okay, great.
Do we have the sound off here? Does this happen?
I can hear you guys. Can you hear me? Nothing.
What the heck is?
Yeah.
It might have been HDC.
All right. Let's convene our closed session. We'll figure out the technology. Sure. Absolutely.
Okay, first of all,
Just for the record, can you just state your name? Yeah, thanks, Nancy.
the agenda item, usually, and I always thought had to have, this may go into closed session. Your agenda item says, that it's, you know, potential litigation, which is usually the buzz phrase, but it doesn't have the language about it going into closed session. So my question for Nick was gonna be, isn't that required in order to go into closed session? Because the idea is notice.
Well, if you would just wait for us to figure out these technology issues, you're welcome to ask him that question, Nancy. Thank you. The original one I had does say this item may be discussed in closed session, so do.
But the original one was 2 o'clock.
No, well,
The one on the Secretary of State.
yeah, no, I'm. Let's let our council answer this and not engage. Thank you.
Yeah, she's saying the notice doesn't say, this item may be discussed in closed session. Correct, please. All right, let me look at Secretary of State. Oh, okay. Okay.
What people?
First one, and I gotta steal it from Nick.
Of course.
I don't think I replied to see it. Yeah, I think the biggest problem at HTC. Because I can't really fix it. Probably turn me off if they can fix it, but it fixes everything.
I think you're perfect for that. Whenever you talk, become full center, if you need to be like co-host or something, there's something there. No, you should be able, yeah. Is that on?
I have no idea what's going on, Laurel. All right,
It doesn't look like it's needed at all.
And of course, my phone deleted his number.
Did George tell you?
Do you think you could find his number, Laurel?
Your phone number?
Yeah.
Isn't that terrible? Oh my gosh. She died. Like over the winter.
This is a mess.
Lawrence's sister.
And I think the meeting was misposted anyway.
Yes. And then like a month later. Brainy?
It's not.
Yeah, brain embolism.
God, I think so.
I know. I know. It was so weird that the two of you were just talking about it the day before. Well, that's why I called him because I was like, well, this is like when would George? First of all, I never see George, and then I sit near him on the ferry, and he said, "Oh, you know, I haven't." We were talking about the party, and he's like, "Oh, I haven't seen Susan in a while," and I was like, "Oh, last time I talked to her, she was like kind of overwhelmed by the taking care of her mom, but her mom has died."
Lawrence, who I also never see, because they're the quietest people over there. Yeah. Such a shame.
Yeah, really.
It's funny because like a good friend of mine, from college lives in Yuriko's building in New York City. And so she, it's sort of funny. I was like, oh, how funny that we share a neighbor, and so I called her to tell her because Susan has been at the building for like the last 12 years taking care of her mother. And so, yeah, Sloan she couldn't believe it either. She's like, I feel like I hadn't seen her, but I thought maybe she wasn't coming around as much because her mom had passed. But, yeah, bummer. So Lawrence was saying that the Smithsonian wants Yuriko's papers from her career as a dancer. And so, they have a historian at the Smithsonian who's waiting for, and that's what Susan was working on. She was working on organizing her mother's papers and journals and playbills and everything so that they could turn them in. So he said now her daughter's working on that. Kind of a cool thing. Yeah.
His daughter's on the Flower Drum song.
Right.
But you're right, they were always very quiet.
Always.
Yeah. And I remember the father out there, he tore out that whole field, used to be that crazy bamboo,
Yes.
and he would dug it all out by hand.
Wow.
Every summer, he would.
And they sort of still do, and then they burn it.
Yeah.
So that's how I know if they're here. I smell that stuff burning. Yeah.
My dad did their roof. Obviously back in the 60s. And they sent him one of the Playbills.
What do you think of it?
And I remember it was like, oh, wow.
You okay?
That's nice.
Right?
And back then you did it. You just didn't know.
We don't know where Nick went. I don't know where anybody went.
I'm wondering if they have.
Do you guys serve lunch here?
It's about to have mine. I wonder if I need to mute
These counselors are having way too much fun down there.
so that it's like.
So he can hear it here and there?
I can hear it perfectly in Millie's office, because we have to open it there, open it here, so that you guys can go into closed session, but I wonder if I mute that one, then this would be the other.
We had this problem, it was at HCC the other night, we had a problem with, and I can't remember how it worked.
Right.
Corey might be in, I don't know.
Oh, Corey was here?
I think Glenn ultimately fixed it, I don't remember who fixed it.
Oh, here's.
He, yes, he could hear us, but we couldn't hear him.
So you got, do you think, he just came back on, do you think we need to mute the one in there, so that this one, it comes through here?
Let's try that.
All right, so which one is this, the code, which one's us? We're co-host in the office. Are we host?
No, host in the office, we're
So if I
co-hosts.
mute
Sorry, I
there,
heard it.
and then, how about now, Nick?
Can you hear me? Nothing? How about now? Still nothing?
Claim the host here. Claim host.
Like those here?
Yeah.
And then, how do I do that over here? Click on this one. Reclaim host. Oh, this is backwards. Okay. What do you say now, Nick?
Hear me? Can you hear me? Nothing?
Now you got
Nothing? Hey, how we doing? All right.
Keisha, we're not laughing, we're laughing at the situation.
Exactly. Hi, Nick. How are you today?
I was concerned it was me. Now I feel a little bit better.
So we've convened the meet. Oh, Marianne, I'll wait for you to come. Yes. We've convened the meeting. Nancy, thank you, raised a concern. Apparently, it is correct on the Secretary of State's website and not on Clerkbase, et cetera. So I'm very comfortable if others are just doing this in open session. I think I'd like to start with Nick just sort of walking us through process, et cetera. We can, of course, ask Nick any questions we have. Nick can be cautious about that because we trust him. And then if there are further strategic issues that are more appropriate for a closed session meeting, we can do that in a properly noticed way on Monday, if people are comfortable with that. Because we
Can I ask a question?
ask away.
I'm good to go open session, but if one is going to appeal, that has to be done by?
Tomorrow.
Thank you.
Yes.
Thank you.
Yes.
I was making sure, so Monday.
But one could withdraw an appeal. You know what I mean? Like
You can
yes.
appeal and then
Yes.
withdraw it.
Right.
Right, but you can't
Right.
not appeal. and then
Exactly.
try to appeal.
Yes.
Yep.
Terrific. So go ahead, Nick.
Sure. Thank you, Keith. So what comes before you is a decision of the town zoning board. It started as a notice of violation issued by the town zoning official related to Aldo's Bakery. I'm sure you're all familiar with the carousel outside of Aldo's. Aldo's, buying through council, took an appeal of that notice of violation. And how that works is the appeal goes to the zoning board of review, and they hear the facts and the evidence and decide the appeal. At issue there was whether or not the carousel is a game as defined in our zoning ordinance or a ride. The zoning board, by a 5-0 vote, decided that the carousel more appropriately fits the definition of a game as opposed to what we commonly would refer to as a ride or an amusement ride. And the zoning board, with that unanimous vote, overturned the notice of violation as issued by the zoning official. It is limited to the facts of this case. For instance, if there were another ride, quote unquote, that popped up in town, it doesn't preclude our zoning official from filing a notice of violation against that. But for this particular game, carousel, the zoning board decided that it was a game and is permitted under our zoning ordinance. What the zoning board also heard evidence on was whether or not this was a grandfathered use, meaning it was a use that predated zoning in the early 90s and has continued on a continuous basis since then. Their decision didn't address that grandfathering portion of Aldo's argument because it didn't have to. They found it was a game, again, not a ride, so it's not barred by our zoning ordinances. So what's before you is whether or not the council chooses to appeal that decision of the zoning board of review. You are free to have a discussion. You're free to ask me any questions in that regard. As mentioned, our deadline to file is tomorrow. We're prepared. James Callahan has worked closely on that. He's away today, so I'm filling in, but he'll be running point on that appeal. I'm just taking direction on his behalf as to whether or not we want this filed in a timely manner. But any questions, I'm happy to help. Otherwise, if you choose to appeal, we would have to do so with a vote.
Can I ask a couple of procedural questions just before
Sure.
we get to, one is, would this just be a decision on the papers by the Supreme Court? You know, like what do they do with this?
So what we would do is file a complaint in Superior Court. It's an appeal of the decision below. So what the Superior Court judge in Washington County, we've had a number of matters with her, Sarah Taft Carter. She would probably set a briefing schedule where we would make arguments based on the record that was created in front of the zoning board, and then she would render a decision. It's not necessarily a quick process, but that's generally what you expect. A briefing schedule, whereas we would file our brief in a set amount of time. The entity Aldo's would have a chance to respond, and then we would ask the judge to make a decision on those papers.
Okay, any questions from the?
Yeah,
council?
so do you have a sense, or were you able to research how the state defines a carousel as a ride, or?
So what would govern, Neil, is if our zoning ordinance defined carousel or amusement ride, which it does not, that definition would govern. As it does not, we're left with the usual dictionary definition of an amusement ride. You can contrast that with a game, which our zoning ordinance does define, and I can read the definition for you. A gaming device is a machine, apparatus, computer component, or item, or items of electronic equipment connected to an electrical outlet by one cord, which upon the insertion of a coin, slug, token, plate, disc, or card may be operated by the public generally for use as a mechanical, electronic, video, or other game or amusement, whether or not it registers a score and whether or not it involves skill. So we have the benefit of a definition for a gaming device, but we don't, in our zoning ordinance, define an amusement ride.
Thank you.
And just to back up a second, amusement rides are prohibited by our zoning ordinance, whereas gaming devices are not.
So with the current standard of if without an appeal, someone else could decide to put a carousel in front of their space if they had it.
No, not necessarily. I'm not sure it carries with it any precedential value that's binding on the town. If there were a similar device and the zoning official asked myself or the land use lawyer whether or not they could issue a notice of violation, my answer would be yes. These type determinations are very factually determinative, excuse me. So it would depend on exactly what the thing is. By way of example, your definition of a gaming device is very specific. Whether it's powered by one cord, whether it takes tokens or coins, you would need the zoning official to look at the facts and circumstances of each, let's say, allegation of a zoning violation and determine whether or not there is a violation. So I don't think that this carries with it precedent, but that's a good question.
But if it's the same exact, make it up, it's the same manufacturer, it looks exactly the same, and let's say Empire Theater wanted to put it in front of their space. Why?
That would certainly be used as argument against the town. Or at a minimum that we're treating one entity different than another.
But is a component of them having this that they also have a gaming license?
Yes, they would still need a gaming license. And I understand that may be coming before the council soon.
Aldo's, no, I'm just saying this more to Neil, that, like, if I had a shop downtown, I couldn't pop up a carousel because I don't have a gaming license. They have a gaming license. But our gaming license isn't specific. I know that when we just did the proposal recently, we had language in there which we did not adopt it, but which would have required that all the games be inside and not visible from the street, but we don't currently have that, do we?
No,
No, we do. Okay, that's what I'm asking. I don't know because I don't have that in front of me.
There's a whole town. That was part of the discussion, which is why.
Please identify yourself.
Okay, sorry. That was part of the discussion at the zoning board too, because it has of 2011, the town has an ordinance on gaming devices that says it has to be inside. It says you have to apply for a license. It has a fee of $150 per license. Pardon? Per item. Per item, yeah.
Right, okay.
So that was part of the discussion that we had, because there's a pre-existing non-conforming use, which the zoning board really couldn't decide, but we put in evidence on. That's why this one is outside, but nothing from today, from 2011 forward, can be outside.
Okay, and I'll apologize because I'm a little muddled because we just put a different proposal forward, which we didn't.
But some of
but
that is already on the books.
Right, okay.
Yeah.
And does Aldo's have a gaming license? Aren't you allowed to have one or two without a license or something? Didn't someone say that at one of the meetings?
No. I'm also kind of curious, with all due respect, Nick, I mean, Don Packer used to always handle zoning and planning issues and appeals. Bill Landry, handled this up until the very last, and then your new zoning enforcement office attorney handled it. I'm not sure why the town solicitor would be handling a zoning appeal.
We haven't made any decisions whether to appeal or who'll be handling it. Nick is our town solicitor, and we're comfortable hearing from him today.
No, I understand that, but in terms of the questions that are asked here today, it comes from the hearing where the zoning solicitor sits.
Thank you.
I've
No
reviewed,
offense to Nick, I
I've
know
I've
he's-
reviewed the tapes. I'm very familiar with what happened.
Yeah, okay, I mean, there's no argument there, but that's what it is, and that's where we are.
Okay, so one more question on, I thought Gary was the last one with the gaming license. So Aldo's does have an existing gaming license?
That was arcade. That was an arcade license that was being discussed at the time. Gaming license, Aldo's has one.
Oh, so it's
Club Soda has one.
Champlin's has one off the top of my head.
Oh, so they're
but
different.
They're limited to 2 or 3 games. They're, like was just discussed, but they're very concentrated in all that.
Okay,
That was different than the arcade, which was a.
okay.
Yes.
Yes, you're.
Just one additional point I'd like to bring up that council did touch on, and I just want to make sure it's explained to the council. This is a circumstance where I'll use the phrase, you could win a battle, but lose a war. By way of example, if the Superior Court Justice found that the zoning board was incorrect, that this isn't a game, it's a ride, and the town prevails in that regard, Aldo's still may be able to prevail on their argument that this is a pre-existing non-conforming use,
Right.
meaning it's grandfathered, so they would be able to still use this anyway. So kind of a nuanced legal concept, but important for you to consider that even in the best scenario, if you were to prevail on the zoning board was incorrect, in your opinion, assuming that you view this as a ride, not a game, does prevail, Aldo's still could theoretically be able to maintain this carousel because of at least an argument by Aldo's buying through their counsel that the use of this carousel or a similar ride, quote unquote, or carousel dates back to before we had zoning laws. And in my review of the tapes, as I just indicated to council, they have photographs that they submitted during these hearings of similar carousels or rides in the same location dating back to the 1980s. I obviously don't have personal knowledge as to how long that this or something similar has been there, but the evidence they presented is pretty persuasive.
And
My-
Nick,
my
if I can
opinion.
ask just, Nick, if I can
Sure.
ask just to our council only, was that continuous use?
I don't know. There
thank you.
wasn't. Correct. Thank you. And that's an important question. It would have to be continuous use.
So,
I would be curious about that
well, I
because,
don't want to.
no, I know, but I'm just saying, I
Yeah.
don't recall
So-
continuous use there, but I have a question about, I mean, okay. So in the minutes, I was at the meeting where this was approved and it was irritating at the meeting, I can say. Particularly because the owners, and it's quoted right, it's like kind of comical that it's right in the minutes too. The owner said that the horse carousel is a game, not a ride, and that the children love riding it. Now, that's exactly what I remember from the meeting. Does that figure into here anywhere? Or the fact that they were asked to remove it by October of that year? Or is this a completely different issue?
I'll take the second question first. Asking to remove it, I believe stemmed from the notice of violation by the zoning official, but Aldos took an appeal. That's their absolute right to take an appeal and let it run its course administratively. So that won't
Oh,
have any bearing.
Excuse me,
Um,
I don't think that's correct. I think the timeline is wrong. We, a majority of the council approved it in the summer of, oh gosh, what year was it?
2021.
2021, and it was supposed to go only and be removed. It was conditional upon being removed by October, which never happened. And then there was an expectation, which was perhaps naive on our part, that they would come forth with a proposal for have a ordinance change, which never happened. And then we just got back into the same cyclical, let's put it up and see if we can outrun the clock, which is what always happens out here.
The applicant
And the-
clearly agreed to remove it.
Yeah, and the,
on this day.
and the other thing that I don't
was
understand
there.
is the lack of the addressing the plan development, addressing the HDC. It's like if it's a ride, and I mean, I think we all agree that's manifestly absurd that it's a game. It's a ride. I, don't think any kid is going to go ask to play the game, and unless it, well, anyway, the oh, I was going with that. So this has gone over a couple of years, and I don't, when I'm driving that road, I'm pretty careful not to be looking at what's around me because it's pretty busy. I don't remember there being anything outside there continuously, but the planned development was the one that I was really worried, really concerned about. And that's come up before.
So Molly, to your question, and Martha, thank you for the background. In my opinion, it doesn't weigh in whether or not they promised to remove it. I mean, I'm not happy with that fact, and it sounds like the council's not happy with that fact. But this is it's an appeal on a set of facts that would go before the Superior Court. That extra or tangential information isn't relevant, and it wouldn't be treated as relevant.
Okay, that's good to know. It's very discouraging. That's the world in which we live, but that's our reality.
But Nick, just to make sure I understood that, and I got what was presented at the zoning meeting, but why wouldn't minutes of the town council be included as evidence?
Because what will be before the court is whether or not the zoning board made an error of law in applying these facts to the definition of a game or a ride. That's the focus question that a judge will have to weigh in on.
Okay.
So Nick, is Martha again, plan development has no role in this, or do they have to go back and get permission under plan development?
My understanding is, and it would probably be a better question for Karen, your new zoning attorney, is that they would now, but candidly, I'm not
Okay,
I'm not
thanks.
100% positive in that regard.
Did you choose, sure, if, I mean, actually, I'm uncomfortable with that. We're trying to have this conversation and question Nick. And if we need further help from our land use solicitor, we'll get it.
Sure.
But I mean, I say that respectfully, but you have a client here and we're trying to talk to our lawyers, sort of get our questions. If you want at the end in summation, that'd be great, but let us continue.
So, Sven, Nick,
Sure.
obviously back to that 2021 meeting, I was pretty strong in my opinion about the fact that it was a ride and that at least it was in violation of zoning from, just keeping consistent here. So I appreciate everything the zoning board does. It's an incredible board. I just don't at all agree with where they ended up. And so from my point of view, I don't know how you can't call this a ride. I understand that they made a decision stating that, but I think my position remains pretty clear.
Okay, anybody else? So, Martha, were you about to? No. So, I'm struggling on this because I feel, I know it's not relevant, but I feel like, as Martha describes, we came to an agreement that I have come to regret, I think, because when we first considered this. I understand it's not relevant to the Superior Court, but then I step back and say, should that sort of feeling that an agreement wasn't adhered to, should that be the driving force of my decision whether to appeal? That's like that is challenging to me. And but the one thing that I am certain about is, what we've learned over these last 2 years is that we very clearly need to update our ordinances to have a coherent definition of what an amusement ride is. I mean, that's sort of what is. If there's one certainty that comes out, it's that you need to recognize that your ordinances are a living document, and you need to actually breathe life into them, whether that's parking or amusement rides or even more sort of grand and impactful things. I have spent more time ruminating on this than that gosh darn carousel ride has taken up too much room in my head. But, I know, right? Exactly.
So can I just ask a question on, how long has it been there? I've lost track. Do we have an idea?
I don't.
21 was be the first year, wouldn't it be?
21?
I don't know. I don't remember. I know.
Well, what Nick said was
It was
there's
that-
evidence that's presented by zoning that a ride like this one was there in the past in the 1980s. My challenge would be, was it
Yeah, that's
consistently
right.
there? And I
Right.
don't think it, well,
Oh, that's
again,
right.
we're,
Yeah, yeah.
Oh,
I
that's
don't
easy
think it was
enough to tell.
consistently there and it's easy to check.
But this ride was
not.
2021.
Right.
Okay.
Right.
This
was the new-
particular
Yes.
ride, which
didn't replace.
with red and white.
without any argument, we would say is much larger, much more noticeable. The fact that nobody can remember another ride being there, despite the fact that there's apparently photographic evidence, would speak to the fact that the other one was much smaller and less noticeable than this extraordinarily large ride. So,
Thank you.
Sven, did you want to say something?
I agree that we need to get to, it saddens me greatly that we need to define what a friggin' ride is
Yeah,
in our ordinance,
Yeah.
and that people are gonna take advantage of that.
yes,
And it pisses me off, to be very
yeah,
blunt.
yeah.
And I apologize, but it's almost like, do I have to define what a shoe is so somebody doesn't trip on the sidewalk because they were wearing a flip-flop?
Yeah,
So from my point of view, this discussion is just further solidifying my frustration with why do we have a ride in town when rides are not allowed? And I appreciate everything the zoning board has done. I thank them. I don't agree with where they are on this.
good. Would you like to make a motion about whether to appeal?
Yeah, I make a motion that we send an appeal on the zoning board of decision as soon as possible.
Is there a second?
I'll second that.
Discussion?
Well, I want to,
Can
go ahead.
I just would like to note that when this first came up, I don't remember, Keith and I and Andre did vote to allow it to stay for the summer. 3 votes, yes, Sven voted.
No, 3 months. Yeah.
Sven voted against it, and Mark, but, and it was in good faith, and I think that that's not supposed to alter anything, but no, it actually, well, I think it does. I think it shows the good faith.
Just,
I guess-
so the history there was, it was in violation, we're allowing it to stay, it needs to go at the end of the season? Was that
A
the?
complaint was filed.
Okay.
They came in, asked for permission to
Yeah,
do
I see
this.
that.
And the council said, I think it was August by the time it actually came to our table. And we said, let it go for the season.
To be very specific, it was the July 21
It was
minutes.
July. Okay, thank
And it was, quote, "Move to grant a New Shoreham game license for the horse carousel through Columbus Day, October 11, 2021.
Yeah, and I think I'd like to reiterate that the zoning board, from when I read their decision, they made their decision very specifically and narrowly off of our ordinance, and the fact that our ordinance did not specify what a ride is. But Bill Landry, when the vote was given, did give specific information about what is a ride. And because we don't specifically have it written in our ordinance what a ride is, does not mean that everyone in this room cannot collectively agree on what a ride is, with counsel for Aldo's excluded, right? So, but I'm just saying, in a crowd of people, everyone agrees what a ride is for the
Yes.
most part. And I understand that our zoning board was acting in the way that they should, which is they were going narrowly off of our ordinance. But in a broader view, that's a ride and it's in violation.
Yeah, and Molly, to follow up on that, I have to say, I think Martha would agree. This was not an easy meeting, because we cast our votes. I shouldn't say we. I cast my vote against the specific guidance of our land use council because and the town manager, because we had a very, unequivocal, in my opinion, agreement that this was going to be gone on Columbus Day. So, Any other comments before we vote? I think I'm going to do a roll call on this.
Can I just also want to say a little more broadly,
Yes.
we have a really varied community here. And this, my feelings about a ride at a business doesn't change my view of, you know, that's a family that we all really like and contributes back to the community in a lot of other ways. But I am going to say I totally 100% disagree on this particular issue. I want to be careful to say that because we are a tiny community and, you know, we can disagree on one item. But I also think that when you start to disrespect the rules that other people are respecting, it creates problems. And that's why we have ordinances, and the fact that we didn't, that it's not defined, as Sven said, you know, a shoe is not defined. If we're not getting that specific on everything, I think we can all agree how we want to respect our community and how we want to respect the people that live here, the people that visit here, the people that are full-time, the people that are part-time, but everybody's got to participate. So that's my soapbox.
Please.
Nick, was my motion defined enough, or did you need me to refer to anything else?
No, I had you, Sven, as making a motion to file an appeal. I believe it was Molly who seconded. That's
Yep.
sufficient for my
Good. I
purposes.
just want to make sure that I didn't need
No,
to read any of the appellate question. Thank you.
No, very good. Thank you, Sven.
All right. I'm going to have a roll call on this, which has become unusual. Neil? Am I answering to? Sven's motion to appeal. Yes. Sven? Yes. Martha?
Yes, and I would say that prior to really thinking about this, the ramifications, the implications, again, the sheer absurdity of it, I really did not think an appeal was appropriate until I looked at the broader picture and looked at the specifics and the pieces of this that the zoning board seemed to ignore, and I am voting in favor of filing an appeal.
Molly?
Yes.
I vote in the affirmative as well. Motion carries. I did, while we were talking, text Millie about possibly adding an item on our agenda for our Monday meeting to not discuss an act, obviously, but to discuss better definition of amusement ride, just so that we have that before us. Anything else to come before the group? Have a motion to adjourn? Second. All those in favor indicate by saying aye. Aye. Opposed, no. We are adjourned.
Thank you, everyone.